significance of this within context. Good morning, ma'am, and thank you so much for making time for this special tribute broadcast.
Good morning, Denver. Thank you for having me.
First things first, did you have any interactions with the founding president? Were you in proximity of him at some stage?
No, not at all, but I was in proximity with some of his advisors or people that he has worked closely with, especially when I was in my first year of university. So they used to come and visit often, and then they would give us these lectures on the adoption of the Namibian constitution, particularly Professor Horn, who taught us constitutional law in our first year.
Very well. Thank you for sharing that with us. Now, as far as Dr. Nujoma is concerned, what do you believe was his main contribution to constitutionalism in general, but in particular the establishment of this constitutional democracy?
Well, to answer that question, I feel it's very important that we establish a context or why the founding father was particularly relevant or how SWAPO came about to be. So it is common cause that when Namibia was given to South Africa as a protectorate in the 1920s by virtue of the Treaty of Versailles, it ultimately meant that whatever laws were applied in South Africa would ultimately then have to be applied in Namibia. And what that looked like was whatever apartheid laws that they had found application within the Republic of Namibia, or South Africa as we had it back in the day. So ultimately what that meant was laws that promoted severe racial segregation, political, economic, and educational segregation as well, or imbalances were highly promoted. And as such, the black nation was treated within an inhumane manner. And by virtue of
in accordance with the law of the day.
In accordance with the law of the day. So obviously, being oppressed, the late founding father, found it necessary to establish what was OPPO, but then later changed to SWAPO to represent the entire nation. And then SWAPO then ultimately had an aim to make Namibia independent of South African rule. And then they engaged in armed struggle in an effort to combat those racial apartheid laws until eventually Resolution 435 was passed. And then we had free and fair elections in 1990. 21st of March 1990, and we have the legal system and the constitution as we have it today.
Thank you for that overview. What you're sharing with us resonates what his nephew, the former government attorney, Advocate Matthias, just shared with us, that it had been that foundation of also SWAPO principles that culminated in the supreme law of the land and this constitutional democracy.
Yeah.
So how are we to interpret his legacy against the backdrop of constitutionalism, against the backdrop of this constitutional democracy and the law in general?
Yes. So his legacy can be interpreted as that which promotes equality and justice for all. You see, he envisioned a Namibia where all of the races, all of the tribe could coexist and have equal rights, and in a democracy for all. So he believed in a legal framework that would fundamentally uphold the rights and the protection of such rights of the Namibian nation, which is ultimately the constitution as we have it today. And the adoption of the Namibian constitution is ultimately the longest lasting legacy of the late founding father, and it would transcend into the generations to come. Yes.
Dare we touch on the principle of happiness? The present-day Minister of Justice, Minister Yvonne Dausap, is of the view that happiness is a constitutional imperative. And hearing you say that based on the Founding Fathers' vision and service to the Namibian nation, we have the Constitution and we have the Bill of Rights providing for human rights. Are we to infer that this would include the happiness of Namibia and her people as well?
Yes, surely. The happiness of the Namibian nation or the Namibian people is premised in the Constitution of Namibia. So the adoption of the Namibian Constitution ensured that everybody is allowed free and fair treatment as we are equal before the law. It also upholds fundamental rights such as the right to own property, the right to life, etc., which ultimately falls into the happiness of the Namibian nation. So to be granted the opportunity to live in a post-independent state that ultimately upholds the wants and the needs of the Namibian people falls into that happiness principle for the Namibia as we have it today.
The very Constitution also makes provision for the role of a president, the role of a head of state. Talk to us about what the Supreme Law tells us about that important function to lead what Dr. Hage Geingob termed the Namibian House.
Yes. So the president or the office of the executive is a very important office as far as the organs of state are concerned. So we vote to have a person in power that would ultimately uphold or that represents the wants and the needs of the Namibian nation. So not only is the president tasked to represent Namibian nation at an international arena, but he is also tasked to ensure that whatever is happening within, whether or not it's a political state or a political scenario, or whether or not it's just a general inquiry, it is very important for the office of the president to know that, okay, fine, yes, I am the president, I have key functions, but it is also my duty to ensure that I don't overstep, or I don't act outside the confines of the power that the Constitution provides to me. Otherwise, that acting outside the powers that the Constitution would then give you would then be an act that is considered ultra vires in law. So it is very important to understand that, yes, the office of the president is a very high functioning office, but it is also limited by the Constitution of the Republic of Namibia to ensure that he doesn't abuse whatever power he has in terms of the Constitution.
You mentioned a legal term, ultra vires.
Yes.
For those of us who are on the periphery, please explain to us what it means in layperson's terms.
Okay, so when you act ultra vires, it means that you've acted outside the scope of your powers, which ultimately means that whatever decision you took in that particular office is not valid and should be set aside because you acted outside the scope of your powers. That's essentially what it means.
To what extent does that principle relate to the doctrine of separation of powers?
Yes. Okay, so when it comes to the doctrine of separation of powers, okay, so we understand that the Constitution separates or establishes three organs of state. So we have the executive, then we have the legislature, and then we have the office of the judiciary. Okay, so when it comes to the office of the executive, so there are certain powers and functions that the Constitution confers upon that executive office. Same goes with the legislature, same goes with the judiciary. Okay, so when you act outside the confines of those powers that are conferred upon you by the Constitution, that action would then be ultra vires, which is a common example is the matter that we have today as far as the elections are concerned. The president's decision to extend the elections, that was a constitutional challenge, and then the applicants argued that it was ultra vires because he acted he didn't act in accordance with the Electoral Act as far as his powers are concerned as an executive. So that is just a common example of what ultra vires means.
Mentioning that very example also demonstrates that as per the Constitution, even the president must uphold the law.
Exactly.
Yeah. Which are the reforms that stand out for you that emanate from the Nujoma era? Yes.
So apart from the separation of powers, the adoption of the Constitution is one of the most important, or it's actually the most important document that now allows for law reform. In other words, when we transitioned from a parliamentary supremacy to a constitutional supremacy, whatever laws that existed in a post-independence era that were contrary to the Constitution would then be deemed unconstitutional and then and thus invalid. So laws that spoke to segregation and so forth was contrary to particularly Article 10 as far as equality before the law is concerned, and as such those laws were repealed. Okay, so it also, one of the other reforms that stood out for me was the independence of the office of the judiciary, which is very important, and that is established by virtue of Article 78.2 of the Namibian Constitution. So it's very important for the judiciary to exercise its functions without any interference from the political arena, because as a judge or as the judiciary, you are supposed to ensure that you are impartial when you approach matters that are brought to you and before court.
Why is that so critically important, that the judiciary as an organ of state ought to function independently?
Yes, because the judiciary is there to enforce the rights of the Namibian people, whatever complaint is there. So, for example, if a judge is partial to a particular political party, for example, and now say I, as an applicant, has a claim against the political party, the chances of the court ruling fairly or coming to a judgment that's fair is slim to none, because he is there, or because the judge in that scenario would then be there to serve the interest of that particular political party. And given that, we would be then denied justice, because we must remember that the late founding father emphasized that justice and equality for all is the utmost important, which is why the Bill of Rights is particularly entrenched, which means that you cannot derogate away from any of those rights. So justice and equality needs to exist in order for a democratic state to exist in the post-independence era.
You explained to us earlier that under the guidance, under the leadership of Dr. Nujoma, we had to transition from a parliamentary sovereignty setup to a constitutional supremacy setup.
Yes.
Help us understand what was the order of the day under parliamentary sovereignty juxtaposed against what we're now seeing under the dispensation of constitutional supremacy.
Yes. So under what is it?
Parliamentary sovereignty.
Under parliamentary supremacy, it means that the Parliament was regarded as supreme. So whatever law they promulgated and passed was considered valid for the very fact that it was passed or promulgated by the legislation. So there was not a system of checks and balances. So even if that particular law passed led to an absurdity, such as, for example, racial segregation or whatever inhumane treatment that result from that, the interpretation of the particular statute, it was still considered as valid simply because it was created or promulgated by Parliament. Whereas in a constitutional supremacy, the Constitution is the supreme law. Okay, so even when laws are promulgated and passed, it must be in line with the values of the Namibian Constitution. So, for example, if there is a law that's passed that would lead to the disadvantage, or which would lead to ultimately the so let's just use inequality as an example. If there's a law passed that promotes inequality amongst the races, for example, and a judge would interpret that and the result would lead to such inequality, we can say that no, this law is contrary to what this constitution seeks to uphold, and as such it should be repealed or set aside. So that would then be an example of how a constitutional supremacy operates. You see, no one is above the law. You are confined and you are limited to what the Constitution allows you.
Even if you are the president.
Even if you are the president, which is ultimately very important. Yes.
Now, in as much as those laws, whether they emanate from international law outside the borders of the country, or even traditional indigenous laws, were contravened the Constitution, were repealed, the laws that are not in contravention of our Constitution, whether it emanates from international law or domestic laws, they could remain in place.
Yes.
Talk to us about that,
which is what we have today. So as you said earlier, the laws are valid for as far as they pass the constitutional test, that being valid. So when we talk about the international arena, there are, the international bodies that promote human rights. And under the reign of the late founding president, we were able to join and we were able to rectify our signatures in those particular international documents and then obviously apply it locally or within the Namibian nation. Okay, so those laws, like for example, equality before the law stemmed from the International Declaration of Human Rights, for example. That is just an example of one of the international laws that we applied here. So it was also very critical in a selective process, because now you need to bear in mind, or the president rather had to bear in mind, what is it that we are trying to promote as a Namibian nation. So when we go to the international arena, we need to ensure that the laws that we are picking, or when we ratify our signature in an international convention, it also needs to align with what we are trying to promote as a Namibian nation.
In terms of our values and aspirations.
In terms of our values and aspirations, which is what the late founding president stressed.
You're raising an interesting point. So what we know about Namibia is if we ratify a treaty, right, we need not domesticate it for it to be applicable. Versus South Africa, where they require that you must first domesticate after having ratified for that to be applicable and enforceable. Is that the right way to go? Once, especially we have established that, yes, that treaty is in accordance with our aspirations, with our hopes, with the values that we stand for as a nation.
Well, the issue of domestication, it really applies, because in essence, that is what we did. Okay, so we affixed our signature to a treaty. We took those laws that apply to our values and we domesticated it. In other words, we applied it locally. So
through ratification.
So it is the right way to, because how else would you then apply it if you don't domesticate it? You understand? So, and by virtue of that, and also the legal effect of affixing your signature to a treaty would then be, should you now act contrary to what the treaty
stipulates,
then you can be held accountable by an international body. So which is also very important. So the system of checks and balances also applies in the international arena, which is perfect because
Namibia is not an island.
Namibia is not an island.
Yeah.
So which is perfect, and the president was brilliant in promoting that as far as human rights and constitutional supremacy is concerned.
Now we have established, we have said that even if you are the president,
Yes.
the constitution is above you.
Yes.
However, that very constitution provides for presidential immunity, both in the instance of criminal and civil litigation. Talk to us about that, please.
Yes, that's true. So what it ultimately means is that when you are in your office as a president, okay, so we can't, while you are functioning as office of the president, lay claims against you, whether or not it is criminal or civil, whatever the case may be. So you would first need to vacate your office. And that is what the doctrine ultimately means. So that is presidential immunity. You are granted immunity from legal action while you are in the office. However,
emanating from your duties as president.
Yes, emanating from your duties as president. However, when you leave your office, you are allowed now to there is provision that allows now for me to lay a claim against you while you exercise your functions in the office of the president.
Particularly if you acted ultra vires.
Particularly if you acted ultra vires, which is what we have today. I mean, look at South Africa. Like right now, they are still holding Jacob Zuma accountable for the actions that he has conducted while he was president. So that is as far as the principle is concerned.
What can the legal fraternity, particularly upcoming young legal professionals, learn from the foundation that the founding president had laid through his contribution to constitutionalism and to lawmaking? Yes.
So we need to understand that the legacy of the founding father was that to uphold the fundamental rights and freedoms of the Namibian nation. And it is also that, and it is also for the importance of a strong independent judiciary, which is what we explained earlier. We explained why it was important. So as legal professionals, we are tasked to, at the very least, uphold such rights and such fundamental rights and freedom to the best of our capabilities in our official capacities, because we need to promote justice. We need to uphold the fundamental rights of human beings, which is why we exist as legal or as officers of court. It's to uphold those fundamental rights and freedoms. So whether or not in this same principle applies to generations to come, you must first and foremost not serve your own interests, but you must serve the interest of the Constitution as far as human rights is concerned. So that is ultimately.
You reminded me of one of the reported bones of contention when the Constitution came into being, relating to capital punishment. And many people who today insist that capital punishment should be returned. However, it's not that simple within the confines of the Constitution. We would need to dispose of the constitutional dispensation for that to be accomplished.
Exactly.
Please explain that to us in layperson's terms.
Yes, because if we look at capital punishment,
the death penalty
particularly, that ultimately violates the right to life. So we must remember that Article 131 of the Namibian Constitution states that the Bill of Rights, or the rights contained in Chapter 3 of the Constitution, are non-derogable, meaning you cannot turn away from them. So, and that is the entrenchment article. So if we...
Although that article isn't entrenched, unfortunately.
Yes,
ironically.
Yes. So what that ultimately would mean is that if we impose, or if we now make capital punishment legal, okay, that would then mean that the right to life is not absolute, which was not the intention of the founding father as far as his contribution to the Bill of Rights was concerned. So we must also bear in mind that that very article, the right to life, is put in the Constitution for a particular purpose, because we've seen, or we are aware, that in the apartheid era, people were being slaughtered for no apparent reason or for trivial crimes. So for that particular fact, we cannot just introduce capital punishment because people feel so. It's not how things work. And there's this gap in understanding. So people think that because they feel a certain way, that's ultimately how the law is supposed to go. But when it comes to court proceedings, it's entirely different.
The law has no business with how you feel.
Exactly. Yeah. The law has no business with how you feel. The law is what it is, and we apply it as per the constitutional aspirations.
Very well.
So that would ultimately set a precedence. Should, for example, capital punishment be legalized, that would set a precedence, because what would that then mean for all the other existing rights within Chapter 3? Does that then mean now we need to amend Article 131 to say that it's actually not, it's not that it's non-derogable, or fundamental rights and freedoms contained in Chapter 3 are derogable under certain circumstances. So that is now another complication in itself.
Problematic indeed.
Problematic indeed. So
thank you for sharing your wealth of expertise today.
Yes.
Do you perhaps, in conclusion, have a message for your fellow Namibians as we continue to mourn the death, yet celebrate the life of Namibia's founding president and father of the Namibian nation?
Yes, indeed. While the death of the founding father came as a shock, and there's certainly a gap in the air, we feel like we have made, there's a loss. We have lost someone of importance, it's particularly the founding father. It should now not mean that we should see his life as that of something that is bad and miserable and so forth. We should rather celebrate his life and be like, look, he has fought, he has fought, he has reached whatever accomplishment he wanted to achieve as far as Namibian independence is concerned. So we must celebrate his life, and in addition to that, we must ensure that his legacy lives on by applying whatever he had envisioned for us as far as the Constitution is concerned. So we must ensure, especially in the legal arena, we must ensure that his legacy lives on as far as the upholding of fundamental rights and freedoms are concerned.
Thank you for your time. Thank you for so generously and altruistically pro bono sharing your expertise. We appreciate you.
Thank you for having me.
That was legal expert Madam Amor Kharugas helping us understand the contribution of the founding president and father of the Namibian nation to law, to lawmaking, and to constitutional